And welcome to this week's edition of the Life and Legacy Show, sponsored by the Sechler Law Firm, where great families make great estate plans. My name is Tim Sechler, and I am the owner of the Sechler Law Firm and certified elder law attorney. And I host this show each and every week to give you the information that I think you need to know to make effective estate planning decisions for yourself, for your family, and for your money and your legacy and all of the things that are important to you. And this week is the week after Thanksgiving. And it is always a busy time in our office because what happens is families get together. Maybe they haven't seen each other for a while. Maybe it's the first Thanksgiving that we took the risk of traveling and getting in a room together. And what happens is almost inevitably, I mean, in our office, inevitably, we get phone calls Monday after Thanksgiving, Tuesday after Thanksgiving, someone starting to ask questions about a slipping senior. So today's episode is all about what you should know when you recognize that, hey, mom's slipping a little, and what are the things that we need to do to get in place now to make sure that we don't have a problem, or that at least we have a plan for um, for what we need to do later if mom or dad or grandma is going to have additional health issues. And so, before we get into this, remember that this show is for your education, it is for your information. This is not legal advice to you. If you have a legal problem, you need to seek legal answers from an attorney. We're available anytime at 724-546-4227. Again, 724-546-4227. Or check us out online, SechlerLawFirm.com, SECHLER lawfirm.com, where you can find out tons of good information about this stuff. I've done lots of educational videos. You can check out all of the now over 100 episodes of this show. You can check out videos and articles, and we put out tons and tons and tons of content just trying to help people make good decisions. You can access it all at SechlerLawFirm.com, SECHLER lawfirm.com, or consider coming to one of our workshops. We have one coming up this week where you can come in at 2 o'clock or 6 o'clock and find out all about the things I'm chatting about today and on prior episodes. You can come in and ask questions. It is me doing the workshop, and you can ask any questions you want. So I encourage you to check it out. You can register at SechlerLawFirm.com. So what to do when you realize that mom is slipping a little? And I imagine what happens is we visit at Thanksgiving or some other event this time of year, and maybe mom's telling the same story for the third time, or maybe, mom forgot her family favorite recipe, or maybe something was just a little off with her tracking the conversation that was going on around her, and then the concern is the siblings get together and they say, "Man, mom's slipping a little," and we need to understand what would happen if she would continue to go down this road. And here's a couple of takes. One is, and I think this is most important, is don't hide from the uncomfortable conversations. Don't avoid the uncomfortable. Because what we see with families that don't tackle these issues is these families end up in our office completely out of control. All right. And what estate planning is, and I've said this time and time again on the radio show, is estate planning is really about using estate planning tools like wills and trusts and powers of attorney, these documents, to manage, control, and access to the family's resources, the family's healthcare decision making. But what we're doing is we're transferring control and access to someone else. And the families that see that mom is slipping a little bit and avoid the issue, or when mom or dad know that they're slipping a little bit and deny the issue, is eventually something happens where now mom is really making mistakes, or mom makes a medication mistake, or mom it goes on a wander, or whatever the thing is, where now it is kind of spiraled out of control. And in some instances, it can get too late to do proper planning at that point. If it becomes too late, mom's capacity goes further and further away from her, and she cannot sign legal documents in the future. Now we're in a situation where the family has lost control. Mom can't take care of herself. Mom never told us what she wanted from a healthcare standpoint. She never named someone else to make legal and financial decisions on her behalf. But now she's had this healthcare event. Now she's had this thing where we can't do it now. We can't ask her. She doesn't understand. And so the key to proper planning is to make sure that we get some planning done prior to the loss of capacity, which if mom's starting to slip a little, then we're probably in a situation where it's time to get this done. So what does that look like? Well, first, I encourage you to get some education, right? We're going to start that conversation today on this show. You can find more information on our website. You can attend the upcoming workshop where we'll chat all about it. But you need to get some education on the crucial documents, powers of attorney, wills, and trusts, and which one may be right for mom, which one, and then once we get our education, then we can have a conversation with mom about, I really think that we need to do some planning. I have seen this occur in other families, and I think we need to get our act together. Okay. Now, I am not a social worker. Our law firm has a social worker, and perhaps we'll do a future episode with her chatting about this. But I've always found that broaching these difficult conversations, is best done with a story. Okay. Mom, I was at work today, and a coworker was telling me that her mom had a stroke, and they didn't have proper documents in place, and now everything's a mess. They're in guardianship court, and it's ugly, and the family's fighting. And mom, I would really like to help our family avoid similar outcomes. Okay, so one of the ways that I think you can start this conversation with mom who is slipping is not to make it feel like an attack. Make it feel like an idea you had because of some other situation, right? The result is the same. You're still looking out for your mom. But if you just come to mom and say, Mom, hey, I was really concerned at Thanksgiving when you didn't know your recipe and you weren't tracking the conversation and you told me the same story 3 times, then your mom is immediately going to go to the defensive, right? She's immediately going to step back and think that, she's going to deny that this occurred. She's going to say that you're overreacting. She's going to say all kind of things. But from my experience, if you start the conversation by saying, Mom, and then reference some other situation you're familiar with, somebody at work, and I like if we are worried about the onset of dementia, we are talking about a more gradual thing where maybe we don't want to be accusational and say, hey mom, I think you're slipping. I like using the reference of a more immediate turn in healthcare that could happen by, like I usually would reference a stroke or like a head injury. Hey, mom, I'm familiar with somebody at work whose mom had a stroke and went from having capacity day one to not having capacity the next day. And the family's in a mess right now. And we can't prevent if you would ever have a stroke. So can we talk about putting proper planning in place? Can we go see somebody? Can we go get some education on what this might look like? So that is one of the ways that I recommend to my families to start the conversation so that the person who we're concerned about doesn't feel like they're being attacked. And in my experience, it has opened up more productive conversation. Okay, so that's just a little bit of tip. Now, all right, so now we've opened the conversation. I really feel like the number one step is to get some education, which is why we put out so much content and why we host these weekly workshops. So come to one of our weekly workshops in Cranberry Township. We're right off the interstate, super easy to find. And you can ask any questions you want, but in the workshop, we go through wills and powers of attorney and trust, and we talk about Medicare, and we talk about Medicaid, and we talk about all the things, different living arrangements. What's the difference between a personal care home and a nursing home? So we go through these different pieces of information that I think are helpful to guide your conversation. Okay. But what documents absolutely should we be thinking about getting in place? And I think this almost always starts with the power of attorney document. All right. So the power of attorney document is a document that's very common that allows the transfer of decision making, the transfer of control in the event that someone has capacity issues later. Okay. Now, the most common way to do the power of attorney is a document called a durable power of attorney, which means the document is effective the date the person signs it, and it remains effective if they would become incapacitated later. There's a different type of power of attorney that has fallen out of favor in recent years called a springing power of attorney, which would say, when I lose capacity, Bobby can make decisions for me. The reason that springing powers of attorney have fallen out of favor is because most people who are having capacity issues don't admit to it. They don't just say, I think you need to start acting as my power of attorney. There's no in there's no judge's order. Or if the idea is, I'm going to name, if your parent names you as their power of attorney when they become incapacitated, what are the odds that they're going to let you take them to the doctor? And what are the odds that they're going to agree with you that it's time for you to take over? And they don't, right? So we draft the thing as a durable power of attorney. It's effective today. It remains in effect if you later become incapacitated, because the way that this typically works, especially with like dementia patients, is there isn't a day one we're fine and a day two we're not fine. Yes, with strokes, yes, with injuries, yes, with other things. But with dementia, it's more of a gradual process. And what I see over time is the power of attorney, the agent under the power of attorney, gradually starts taking more and more responsibility for mom. It might start with making sure that the bills get paid. And then it might start with, and then it might go to doing all of the banking. And then it might be reviewing all of the mail so mom doesn't make a mistake. And then it might be making all of the financial decisions for mom because she simply can't. But there wasn't a day where mom had her legal faculties and then the next day she didn't. It's more of a gradual takeover. And the durable power of attorney is a very effective document to effectuate that reality. Okay. Now, if you have a power of attorney document already, whether it's yours or whether it's mom's, I encourage you to read it. All right. And determine if perhaps it needs updated. And what does that look like? There was a law that changed in 2015 that created certain provisions in the power of attorney documents that need to be expressly stated in a certain way. Prior to 2015, it wasn't required. After 2015, now it is required. And one of the key provisions is the authority to do gifting. So let me explain why this is important. When in our office, we do cases that we call crisis cases, which is where mom has now entered a skilled nursing facility. Skilled nursing facilities in Pennsylvania are about $15,000 a month. And we now have this huge financial problem. And it's usually the power of attorney, the agent under the power of attorney, that approaches our office and wants to know, is there anything we can do to stretch mom's money? She's going through the money too fast. We're not going to be able to provide for her care for a long period of time because we're losing it all. And is there anything that we can do to preserve money for dad, who's doing fine, but we're losing all of the money? And in those cases, what we're talking about doing is what we call Medicaid crisis planning. And there are things that we do to help families become eligible for Medicaid to pay for the nursing home so that they don't have to go broke, because without proper planning, you will go broke. So when we're doing these cases, one of the things that we almost always are going to do, right now, again, little disclaimer, this is not self-help. Okay. If you're in this situation, see an attorney. There's lots of mistakes to be made. But one of the things that sometimes makes sense is if mom is in the nursing home, we transfer assets to dad, or we transfer assets to the kids, or to a disabled child, or to a trust. But there's lots of different strategies that we can use to protect money. But we almost always have to get it out of the sick individual's name and into someone else's name. Well, if we're doing this pursuant to our power under the power of attorney, the power of attorney document had better authorize the unlimited gifting. We had better be able to do this, because the difference between losing the home and keeping the home may be as simple as putting it in someone else's name in certain fact patterns. But if the power of attorney document does not authorize the agent to do that, it we can't do it. I can't advise a client to transfer an asset to a disabled child if the power of attorney doesn't authorize the transfer. Right? So, in my opinion, for folks who are concerned about this stuff, we really need to have very, very strong gifting language in the power of attorney document to authorize these transfers. And to me, this is just such important planning. And so many families miss it. They go to a lawyer or they print off some document online, And the way a power of attorney document sets up is there's a notice page on the front in Pennsylvania that you have to sign. And then it gets into, I'm Tim, I name Bobby as my agent under power of attorney. And then here's all the things Bobby's allowed to do. In one of those paragraphs typically involves the transfer of assets, gifting the assets to someone else. If it's not there, I suggest you come see us about updating that document. For a couple of $100 document, we might be able to save your home. Right? The second is sometimes it'll be there, but it'll be limited gifting. This is very, very, very common. The document will be vague. It'll say my agent may give gifts, or it'll say my agent may give limited gifts, or there might be a reference to like an IRS code section, and my agent may give gifts as limited by blah, 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 blah. This is all of these examples are limited gifting language. Limited gifting is the default rule in Pennsylvania, and limited gifting, unfortunately, only authorizes the transfers of up to $16,000 to certain individuals. $16,000. Well, let's say that mom's house is worth $250,000 and we might be able to protect it by transferring it to someone else. If the power of attorney document only authorizes us to transfer $16,000, we don't have the legal authority now to transfer the $250,000 asset, and our hands are tied. We may lose this house to the harsh government rules, right? And so I implore you to come see us, talk to us about the power of attorney document, understand that they are not all the same. Just because you are a power of attorney or you're the agent under a power of attorney, or just because you have signed a power of attorney document with the corner attorney, doesn't mean you have what you actually need when times get hard. Let's make sure you've got a power of attorney document that allows us to shift into four-wheel drive when things get muddy. Okay. Now, that's my conversation on the power of attorney document. So what we've been chatting about today is this occurrence that happens this time of year, every year. And that is that you get together with family and we realize that one of our senior family members is starting to slip. Um, they're not thinking the same way. They're not tracking the conversation. They are telling the same story a couple of different times. You know, the indicators that maybe something's off here. And how do we start the conversation? And what documents do we need? And we started with the idea that we need to do some education first. The idea, this is the idea behind us doing our weekly workshops, is we're trying to advise people on what they're up against with these government rules and what documents they want to put in place. I can't tell you how many times in our office we are approached by a family, and it's usually the adult children who are now in control. They're now in charge because something's happened to mom, and they have no idea. They have no idea how much money mom has. They have no idea where mom wants to be taken care of. They have no idea. They don't know, and they don't understand the system. You know, a 50-year-old son doesn't know the difference between Medicare and Medicaid. They've never had to become educated on Medicare and Medicaid. They don't know the difference between a personal care home and a nursing home. To them, it's all the old folks' home, right? But there are very key distinctions here that we can make helpful and impactful decisions if we just get educated. So come to one of our upcoming workshops and give that a go. And then the next thing that, you know, we discussed the importance of the power of attorney document. Yes, that to me is the most important document when it comes to helping someone with capacity issues. And then we can talk about trusts, and then we can talk about wills, and we can talk about asset protection, because it's possible to put assets into trusts and protect them from long-term care expenses. And it's possible to do that when someone is starting to slip and we have plenty of time before they actually need higher levels of care. Now's the time to take action, because nursing homes in this Medicaid system that pays the nursing homes, there's a 5-year look back period. So if someone's starting to slip now, in all likelihood, we may have 5 years before they need skilled nursing. We might not have 5 years before they need some help, but we might have 5 years before they need skilled nursing. And by putting some assets into a trust, we might be able to protect them. Okay. The other component of this that has nothing to do with what we do here at the law office is, you know, I made the point earlier about not avoiding these uncomfortable situations. There are medications that can slow down the progression of certain dementias. They're out there. So don't shy away from an uncomfortable conversation because there are ways that the medical community can help. Dementia is not wholly preventable. Alzheimer's disease is not preventable. Right now, if I'm on the Alzheimer's train, I can't get off. But when it comes to the time that I start to my memory starts to go away, there are medications that can be used to slow down that aging process, to make sure that we have a higher quality of life for a longer period of time. So don't miss the opportunity to really help your senior by resulting out of the fear of having an uncomfortable conversation. I see it happen all the time. And the next thing that I think is important in the last couple of minutes that we have here is ask the tough questions. Mom, if you needed care, where would you like to receive that? How are we actually going to get this done? Okay, you say you want to stay in your home as long as possible. Look, I love that. All right. I'll help any way I can. But the reality is, Mom, I have a job and I've got kids and I've got this and I've got this and I've got this. Um, in certain families, family caregiving can solve all these problems. In other families and other fact patterns with different healthcare issues, family caregiving doesn't solve all the problems. So if we needed to turn for help, are we going to go to a home health agency? Are there some that we should start talking to? Should we start doing some homework on this? What if we had to go to a residential community? Maybe mom, in addition to slipping, also has mobility issues. Maybe we're concerned that she shouldn't be by herself all the time. Do we need to look at a more protective environment? Should we think about a personal care home, assisted living? At what point in time do we need to take a look at skilled nursing? And given these healthcare needs that we have, how are we going to pay for this? What payment sources can we use? What are the assets that we can use to pay for this if we need it, to pay for this if we need it? And if we need higher tiers of care, can we access government programs to help us pay for that? And what I'm talking about is starting the conversation of what we call around here a life care plan. The care of a senior can be planned. Is the plan going to be perfect? No plan is perfect, but we can at least get the seniors' goals. We can at least get the understanding of their finances so that we can effectuate those goals, and we can put it in writing. And one of the reasons that here at the Sechler Law Firm we employ a social worker who's been in geriatrics her entire career is because she will sit down and chart out in what we call a life care plan. A life care plan is understanding the senior's goals for care now at this baseline level and what may happen if the need for care progresses. And if we need to go here, then this is the solution. We've chatted through it. And as part of that, we line up the estate planning documents to effectuate those goals. If we're going to go to a personal care home, which we're going to pay privately for, these are the funds that we're going to use. If we need skilled nursing, this is the place we're going to consider going. And this is how we're going to pay for it, which may contain veterans benefits, Medicaid benefits, different payment sources. But these choices are going to have to be made, right? I can't change if my parent is going to get sick, but I can think about how my parent or how I myself am going to receive that care. Let's face it, we're all going to get sick. So if I'm going to get sick, where am I going to receive my care? How can I communicate that effectively to my family members so that they're not guessing? And what we call that at our office is a life care plan. And the starting point for getting started with this is to come to one of our educational sessions where we're going to teach you the technical stuff. Wills versus trusts, revocable trust versus asset protection trust, how to protect assets, taxes, the technical legal things that you need to understand before we can start implementing. It's essentially, if you think about these different documents as estate planning tools, we're essentially getting out the toolbox and explaining tool by tool what it is and how's it used. And then we'll talk about which tools are right for your situation. All right. Based on what you told me, you need a screwdriver. You don't need a hammer. Right. Um, Based on what you told me, you need a trust. You don't need a will. And so once we have the foundation knowledge, then we can explain how these tools, these documents impact how things are going to go when life throws us a curveball. So I hope that this episode hit somebody at the right time, somebody that is saying, yes, this is my mom. My mom is slipping. We need to get on top of this. I hope that this will help people make good decisions, review those power of attorneys to make sure that we have what we need if things get harder. Remember, folks, this is for your education, your information. This is not legal advice. We're happy to provide legal advice. You can find out more about the Sechler Law Firm, about me, about how we do it by visiting the SechlerLawFirm.com, SECHLER lawfirm.com, or give us a call at 724 546 4227. Again, 724 546 4227. I hope you had a great holiday. I hope you're looking forward to more great holidays, and I hope you get some ammo for how to have some difficult conversations today. Have a great week.